SJC-13347, Boston Firefighters Union Local 718, and others, the City of Boston, and another.
Okay, Attorney Foskett.
Madam Chief Justice, may it please the court, John Foskett for the City of Boston and its mayor. Before you is review of an injunction entered by the single justice, which enjoined the city's vaccine mandate by finding all 4 of the required elements for injunctive relief. We say that findings on all of those are an abuse of discretion within the standard of review regarding this sort of order entered by the single justice. Regarding likelihood of success on the merits, last week, the Relations Board actually decided that issue in a proceeding that had been brought by the unions simultaneously with this lawsuit. And in that decision, which has been submitted under Rule 16L, the Relations Board made the following rulings. It ruled that the city had the non-delegable managerial power to make the decision to establish the vaccine mandate. It further ruled that the city could engage in expedited impact bargaining regarding implementation of the vaccine mandate. It ruled that the city had not violated 2 MOAs that had been entered into with 2 of these unions regarding testing in September of 2021. And it steered one issue, it left one issue to be developed at a hearing, and that was not whether the city could impact bargain the vaccine mandate, but whether the city's establishment of the deadline in that impact bargaining reflected proper public policy.
Can I ask, is it the same, sorry, is it the same case, or is it a different case? That confused me a little bit, because I thought the CERB's decision is very sophisticated, and it seems to be, applying impact bargaining analysis correctly. So if we think that's a good decision, is that actually the same case as this one, or is it a different one?
What I'm saying is that that decision decides the finding here on likelihood of success on the merits for the unions, because what the single justice did was rule, without specifying any details, ruled that the city had violated its bargaining obligations under the statute.
I had a little trouble understanding what she did. Did she decide this on decision bargaining or impact bargaining? If you read the ruling, it doesn't differentiate. Right.
It simply says the city violated its bargaining obligations, so all you can do is look to the arguments that were made to her by the unions. And
sometimes she refers to Judge Locke's decision, which is an impact bargaining analysis, right?
That's correct. And that's a little complicated too. What Judge Locke did was said he's not deciding the likelihood of success on the merits. He then made what he called an observation, and it was focused at a minimum on impact bargaining. I believe she cites that in a footnote.
So can I ask you a question on the CERB decision that you started off with? Does that moot this case? I'm trying to understand what the impact of that case is on our case.
The connection
suggests that it's binding in some way.
The connection is, what happened was simultaneously after the December 20th announcement of the vaccine mandate, the unions filed unfair labor practice charges in the DLR and brought this lawsuit. They were simultaneous proceedings, basically making the same allegations, which are that the city has violated its bargaining obligations. The unions in both cases have specified decision bargaining, impact bargaining, and 2 of these unions had testing MOAs that had been entered into in fall of 2021, and they claimed those were repudiated.
So these were parallel tracks. So what is the impact of the CERB decision on the case that is before the SJC now?
Well, one way to look at it is one of the amicus briefs that has been submitted on the side of the unions basically says that the injunction should stay in place until the SERB's final decision. We have a final decision. That goes, of the 4 elements for an injunction, that goes to likelihood of success on the merits. Again, she did not specify whether her ruling was based on impact bargaining, decision bargaining, repudiation of the MOAs, or any specifics. It simply said bargaining obligations.
But you didn't quite respond to Justice Wendland's question, though. So your position is not that the CERB decision makes this issue moot. Its reasoning just augments your likelihood of success argument.
Correct. In other words, what they have done is apply this court's Worcester decision, which we've relied on, which talks about the general rules establishing a non-delegable employer policy, impact bargaining, et cetera. They've taken that, and they've taken this case, meaning, when I say this case, I mean this vaccine mandate and its implementation, and they have said, again, that A, this is the decision to issue the vaccine mandate was a non-delegable authority of the city. It could engage in expedited impact bargaining, and it did not repudiate the 2 MOAs that are at issue. So they are...
But it doesn't, it reaches a different, the result is still up in the air, right? The ultimate result of whether the impact bargaining was complied with
the one
is
issue,
still uncertain, right?
The one issue, Justice Kafker, has to do not with whether the city could engage in expedited impact bargaining, but whether the deadline it set, the original deadline, was reasonable. And what they've done is they said they're not ruling on it. They are sending that limited issue to hearing for the hearing officer to determine whether policy considerations, et cetera, made that reasonable.
I get that, but it's a related question to the one Justice Lowy asked, though. Is this whole thing moot, though? Because, you know, the city pulled the policy for the other employees. They didn't require vaccination, and then circumstances have now changed again. So even if the CERB rules that the city should have done more impact bargaining, both pre and post, or post, it doesn't resolve anything, does it? I mean, I'm trying to understand what's really at stake still.
Well, it does resolve the decision bargaining issue.
It resolves whether this past circumstance with a policy that it's not clear the city's still planning on enforcing was consistent with their labor law obligations, right?
That's correct. You know, that's the policy that is still in place at the moment.
Is there a policy in place?
Yes.
Meaning the city would like to vaccinate the employees or not?
The city still has in place this vaccine policy for the primary series. This has all been the subject of litigation. We're a year away from when the city announced the policy, but the city does still have the policy in place.
That's what I just want to make sure that's what confuses me a little bit, because, again, the mayor withdrew the application of vaccines to all employees after the injunction went into place.
What's
right?
happened is, pending decision, they have engaged in bargaining issues that can maintain the status quo, more or less.
Is there a mandatory vaccination policy currently?
Pardon?
Is there a mandatory vaccination that would apply to these employees currently?
It's in place, and it applies to all employees. What they've been doing is moving the deadline, if I can put it that way.
What is the current deadline?
The current deadline is pending the result here. Initially, if you read the SERB decision regarding these unions, the deadline was pushed back a couple of times. That's one observation the SERB made. So the point being that, taking into account the input, the expert input of the Public Health Commission's executive director, the city's been balancing that by pushing the deadline out. They have not lifted it as to all employees.
So this is, when I say this is a moving target, the pandemic is a moving target, and this litigation is a moving target. And so if you could help me out here because of what we're deciding, because you have Judge Singh's single justice decision, Judge Locke's decision. What we're looking at is impact bargaining, exigency, what's reasonable. Hold on, my question's coming. What's reasonable? So that's all moving.
The one thing that's not moving is the establishment of the policy. In other words, that policy is still in place. The SERB has pointed out that the wisdom of that policy is not something that courts or the agency should get into. What's moving is the bargaining process.
And what's reasonable is different depending on the moment of the pandemics.
And again, the only example I can give is that even right after this was initiated, engaging in impact bargaining, the city moved the deadline 2 times. So yes, that's moving because here we are. As we all know, this pandemic comes and goes and comes and goes. The implementation, sitting down and bargaining at the table, is going to be based on the Public Health Commission's.
I guess I'm having a hard time because I don't really understand what it is the SJC is deciding and whether or not that's moot. You keep talking about the policy, but this amorphous moving deadline dependent on our decision as to what the single justice did. Is that where we are at?
What you're at is there's an injunction that essentially says until final resolution of this matter, the city can't do any of this. They can't have a mandatory vaccine policy. They can't impact bargain in this manner, regardless of where that leads or how it goes, and they've repudiated the 2 MOAs. That's what you have in front of you, because that's what she has said. The city can't adopt the policy. They can't do any of this. And what I'm saying is that the 2 things that the SERB has said the city can do are this policy. The city can adopt this policy, and the city can engage in expedited impact bargaining of this policy.
But we clarify legal issues. So, I mean, I take it we can clarify, one, that this is an impact bargaining decision, not a decision, right? This is an impact decision, not a, decisional bargaining issue, right? I take it, is that still up in the air for us?
The only thing up in the air, I keep going back to the SERB's decision because, as we all know, they're the primary.
Well, we get to say what the law is. We could say that the SERB is wrong, but
you beat me to it. Yeah. I was going to say that they are the primary applier of the law. You folks ultimately decide questions of law. But my point being,
but if we think their analysis is correct, and the place they are is correct, which is that this last issue about, okay, again, it's an impact bargaining decision, there is an exigency, but the city may not have complied with its bargaining obligations, and that issue is now before the SERB, actually the administrative judge again. What do we do?
And again, that limited issue is simply whether the specific deadline in this case at the time was reasonable.
That raises Justice Lowy's issue, which is, are we deciding something that's of no import anymore because the world has, the level of infection has changed, the city we don't know what the city's planning on doing.
The problem is that the city can't do anything right now.
So this is really for next time, right?
Pardon?
This is really for the next time the city needs to implement a policy.
It's for now because the city can't even have this policy under the decision.
But the city may not want this policy by the time that given where we are.
But they're barred from, they're actually barred from having this.
And that's why you need to know whether it's okay going forward.
Right.
To implement what
you have to know whether the single justice's decision is wrong. But if we wrote simply that the single justice decided this on decision bargaining, not impact bargaining, that was incorrect for the reasons stated by the SERB. Are you happy? Is this over for you?
In other words, if the
injunction was improperly issued, but these other issues are still live and to be decided, is that fine by you?
I get, Justice Kafka, I really need to know which issues.
Well, again, the injunction is before us.
Right.
It appears that it's a decision bargaining rather than an impact bargaining decision. But I don't know if that's...
I think it's all because, again, the impact bargaining, they've cited a case that says that impact bargaining has to take place in successor negotiations. So, again, all I can say is the SERB has said what decision can be made here. It has said what type of impact bargaining can occur. The sole reservation is to the original deadline.
We could just say this, that's not correct. We could take the single justice's decision and create and explain what we think the law is, and it could be inconsistent with what the SERB did.
It could be.
Right.
It could be. I'm simply saying that's what we have right now on this
Let
issue.
me try the question a different way, if you could, just to help us out on what we're deciding. We've got to hear the other side of this.
Sure.
But for the purpose of my question, assume that the single justice of the appeals court's decision was decisional bargaining. And assuming, for the sake of this question, that's wrong. Why would we be chiming in right now on what's reasonable impact bargaining back when the pandemic was in a different place?
That, again, that's why I go to what the SERB said. The specific issue here is the deadline that was imposed here. The concept is that the city can engage in expedited impact bargaining with all of its employees subject to this, wherever that leads, including, as the SERB has suggested, reasonable deadlines. And impact bargaining, as you know, can result in all sorts
I know,
of
but
different...
here, so what's an exigency? What's reasonable? All of those things depend on the moment of the pandemic, right?
They're tied to it.
Okay. So then why is it, again, I have no idea where we're going to come out on this, but if it's decisional bargaining and that's wrong, why are we going to try and analyze what was reasonable as it relates to impact bargaining and deadlines?
I'm not sure you have to drill down to that level of detail on the impact bargaining. I'm just stating the general rule that they've come up with.
But how do we, you want us to reverse the single justice, right? Because you're saying that the single justice is an impediment for the city to move forward. But the single justice decision could be right for the wrong reasons too, right? We don't know in the end of the day whether the city has violated its impact bargaining obligations, even under the SERB, right? We don't know that, right?
We don't know that.
Right.
But again, in terms...
So, okay, we're looking at the time, Justice Lowy is right, but we have to decide at that time, do we have to decide that? At that time, back in January or December, whether that was an error?
That's why I'm saying that the limited issue that's being sent back for hearing is so specific to that specific deadline that I'm not sure you have to decide that. What the SERB, again, I keep saying the SERB
How do
is...
we reverse the single justice? Can we reverse the single justice without deciding that issue? That's what I'm not sure I understand.
Again, the city's enjoined from going forward today in terms of impact bargaining and setting reasonable deadlines. So whether that specific 2-week window, and it is a 2-week window if you read the decision, I don't think you have to resolve that. I think you just resolve the notion that the city can engage in expedited impact bargaining decision, and it can make the decision without bargaining. I see my time is up, so we'll rest on our briefs.
Thank you very much. Okay, Attorney Bryant.
Thank you, Madam Chief Justice. May it please the court, I'm Patrick Bryant on behalf of the Boston Police Superior Officers Federation. We're splitting our time today. I'm available to answer questions on any subject. My intent is to focus my time on the bargaining obligations or likelihood of success issue. My sister counsel be focusing on the harms and the balance of harms issue under the analysis. I think this case can be decided.
You start with the mootness issue. Is it moot or not?
I believe it is.
Well, I mean, legally.
Yes, because what I think needs to be clear is the injunction applies only to 15% of the workforce. There are 18,000 employees. The city of Boston has abandoned the policy as to 85% of the employee workforce. If the policy exists, it exists on paper. So there is no purpose that is served, I think, by going further on this case and deciding the decision.
But mootness doesn't depend on percentages of employees affected. It depends on whether or not there's a live issue left. So it seems what you just said suggests that at least for some population of employees, this is still a live issue.
For some population of employees, yes. Well,
for your client.
no, it's not a live issue as to anyone because the policy is not being applied as to anyone.
Is that because of the injunction?
No.
Okay.
So again, the standard, this can be decided based on the standards that the city set forth.
Isn't I don't know if Mr. Foskett said this, but isn't the point, the argument is the city wasn't going to apply it to 85% if it couldn't apply it to the critical 15% who are public safety employees. And that's why they backed down. Or is that not true?
That, I think, it doesn't make logical sense because, for one, there are many public safety employees, including patrol officers, of which there are nearly 2,000, including paramedics, the people who are most acute in responding to the vulnerable population they identify. You also have teachers. They talk about, in their brief, the concern about vulnerable children and how they might be exposed. Teachers, paraprofessionals, clerical staff, all of those individuals who spend 6 to 8 hours a day with individuals are not required to be vaccinated, are not required to test, but now the city is claiming it is hamstrung by this injunction. The standard that the city set forth at page 19 of its reply brief is the mayor did what any responsible leader would have and should have done. And what she did do is not apply this policy. What she did do was abandon this policy. She had the right, arguably, in December 20th, when this was announced, if they actually thought that unvaccinated, asymptomatic employees were a threat to vital public safety services, they could have removed them from service pending any bargaining obligation.
Does that mean that the CERB case is moot too? The one you're trying to win there?
It's not moot in the sense of it is still an issue whether at the time the city violated its legal bargaining obligations.
Well, but so isn't that the same issue that's before us? At the time the city did this, did it violate its obligation?
Yes, and in the context of an appeal from
and I take it that some people got vaccinated who didn't want to get vaccinated.
Correct.
So is it really moot? I mean, it may be, but it just seems to me that it's not so much moot as that it's shifted locations in time. The past issue was being dealt with by the CERB, and the future issue we can't resolve because it's, as Justice Lowy says, so fact specific.
I think that plays a number of different ways, one of which is that it is fact-specific, and at the time that this was announced, the city was not acting consistently with its statements in terms of how it was addressing employees. Moreover, to the degree it had some non-delegable right, which is a judicially created doctrine that's to be decided by the courts.
Well, but it's again, we tend to like expert agencies to weigh in first, and the CERB is an expert employment. They're expert at this, and it seems like they're applying our law the way we set it out, which is drawing distinctions between impact and decisional bargaining, and then in exigencies, you only have to do a certain amount of pre-implementation bargaining. So they seem to be doing just what we say.
And I think what they did in this case that is pertinent to this case, again, needing to go no further than the standard they set forth. The city set forth, they have an impact bargaining obligation. They admit that. The city said the spam decision decided by the CERB should apply. CERB applied that spam decision in the context of this case and said the evidence shows the city violated its impact bargaining obligations. So for purposes of...
I don't think they went that far. They said that they're sending it back because the administrative judge made a determination that it had complied with it, and they weren't sure whether it had or it hadn't, right?
It was an investigator, not an administrative law judge. So the investigator issues a complaint. It will then go before an administrative law judge who will hear evidence and then decide whether the evidence established it. But what is most important is the CERB decided that on the evidence that was produced, the evidence that's also before you, that the city violated, the evidence shows the city violated its impact bargaining obligations. It was unable to establish an affirmative defense that the deadline set was reasonable and necessary, and the CERB specifically cited the fact that the city has abandoned its policy with regard to all employees. Once the single justice implemented the temporary stay at the end of January, the city said no patrol officers, no teachers, no paramedics, no clerical staff, no janitors, no one else is going to be subject to and required to be vaccinated as a condition of employment. That goes to the heart of the city's argument that this is non-delegable because it's vital to public safety services. It cannot be that this is essential and vital to public safety services, and yet those same public safety services can be provided by unvaccinated, asymptomatic employees. The city...
I'm reading the last sentence of the order. They remand this matter to the investigator to issue a complaint to allege. Is that have they made a finding that they violated it? No.
No, they've sent it back to the investigator who decides whether a hearing will be heard. And so in the other case, in the spam case, they said no, the evidence was really beyond dispute based upon the facts as they were determined by the investigator. It was reasonable and necessary in the context of spam.
How can we, is the single justice's decision inconsistent with this and therefore should be reversed?
It's not inconsistent with it at all. I view the single justice as...
Doesn't do any of the analysis. She doesn't interpret any of this. She just says it's a decision. I mean, I don't know if it's a decision or impact, but she doesn't do any of the analysis, including all of the analysis that CERB says is correct. She just says the city is wrong altogether, but she doesn't go through the steps, 4 or 5 of which the CERB says the city did properly.
Because she was relying on the Superior Court decision. I disagree with my brother counsel. I think the Superior Court decision is extremely clear about its finding on the likelihood of success. It didn't need to reach the issue, but it says the city unequivocally has an obligation under Chapter 150E to engage in collective bargaining regarding the impact of that mandate. Because the city failed to do so prior to December 20th, the plaintiffs have established a likelihood of success on the merits.
Again,
at least as that causes...
that short circuits the analysis too, because there's the exigency and there's the pre and the post bargaining. That just looks at it as all impact bargaining has to be done before, right? That's the
Generally speaking, impact bargaining has to be done before.
Not in an exigency. In an exigency, some has to be done before, but then we move it to the post because it can't await resolution, because that's what an exigency is.
But that's where the CERB decision becomes highly relevant, which is to say when the agency that you believe has the expertise in here and to which we should defer, when they look at the issue in a way, they decided the way that the city did, the evidence establishes, subject to a hearing, but the evidence shows a likelihood of success that the city, based upon its disparate conduct here, violated its bargaining obligations and was unable to establish its deadline was reasonable and necessary.
What if we can't do the last part of this? What if we can't determine whether the city did or did not do the amount of pre-implementation bargaining that's required? What if we can't do that from here? We're not fact finders. And what should we do in that context where we agree with basically the approach that the CERB has set out, but there's a factual issue it hasn't resolved either on that time period? What should we do?
I think it should be defer to the agency process for that fact-finding to occur. To the degree that you believe it should be attendant to an injunction, there would need to be some kind of evidentiary hearing based upon that. But I think the evidence is also, again, on the facts that the city can't dispute, that when it made this announcement, people were still required to work despite being asymptomatic and unvaccinated, that the city did not offer bargaining dates for nearly 2 weeks until after this announcement came. The city provided 1 month instead of 2 months to bargain this compared to spam. The city didn't have authority when it met with the individuals, didn't respond to the proposals. So the evidence, I think, is sufficient on the record to be able to decide at this stage, look, the evidence shows the city wasn't meeting its impact bargaining obligations, or otherwise the deadline was not reasonable and necessary.
Thank you.
Thank you very much.
Attorney Baralt.
Good morning. It's Leah Baralt, and I represent the Boston Firefighters Union Local 718. So the one thing I did want to focus on the other two arguments being made by the city, but just kind of in follow-up to what my brother was saying, and with respect to a question that was asked by Justice Kafker, I do think the single justice decision is consistent with the SERB decision, sort of along the lines of what...
I find that really hard to do, because she doesn't do any of the steps, and her analysis on harm is also complicated. That's why I'm glad you're up on harms. Because, again, she just skips all of this. And this focus on harms, she says, is very unusual, the way she defines the harms.
And so on the first point that you're raising, the one thing I just want to maybe...
let me just qualify, just to pose the question. So if we think this is an impact bargaining decision, not a decisional bargaining issue, don't the harm analysis, that affects the harm analysis too, doesn't it? Because, again, the city is going to be able to, this is a management prerogative that they can implement if they properly do some pre-implementation, some post-implementation. So eventually they get to do this. They just have to talk it through and deal with the impacts. Isn't her harm analysis inconsistent with an impact bargaining responsibility as opposed to a decisional bargaining?
No, and maybe that's the point.
That I need to better
Sure.
understand.
Let me try to sort of clarify it in a different way, which I think it's important to note that when the unions brought these charges, they brought them as a decisional or impact obligation that was violated. And I think also what's important in these decisions about non-delegable rights is that the case law is clear that even when you have these non-delegable rights, there is still an impact bargaining obligation. All of these obligations are pre-implementation. There is a small affirmative defense.
It's just more complicated. Some of it's pre-implementation, but again, if it's an emergency, a true emergency, and it's a management prerogative, they don't have to bargain indefinitely. They can do some of the bargaining beforehand and some of it afterwards, right? That's what we got a lot of law on that point.
Yeah, and it's a great point, and I think this is where the single justice and the SERB are consistent in that they're saying in those limited situations where the affirmative defense of exigency has been proven, then you do have the opportunity to do some bargaining pre and post. What SERB has said, though, very clearly, which is consistent with the single justice and the Superior Court, is that the city has not established the affirmative defense of exigent circumstances. That hasn't been established.
Is that what they said, or that they didn't establish, there is an exigency, but they didn't necessarily set the time right for the exigency, meaning that they compared it to the spam case where the Commonwealth gave out 2 months to bargain and the city only gave a month. And they're saying 2 months, the exigency can be dealt with within 2 months, but 1 month, you're compressing the time too much.
That's a very narrow view, of that decision. I think the city's pulling out.
Isn't that exactly what they said, though?
No, I think what they did on the factual record, I also think when you have to look back at the spam decision with SERB, this was a different time frame. It was very soon after the pandemic had started. It was a completely unvaccinated workforce, and they did set a 2-month bargaining deadline. This is factually distinct, and the SERB rules this from what went on in Boston. We had a policy in place in September. It was a testing policy. Then in December, this new mandate came into play. At that point, 87% of the workforce was vaccinated. It was a very different factual scenario. And yes, they did also reference the deadlines and the fact that those were moving targets, because to SERB, the fact that they kept extending it rose the issue to them of, is this really an emergency? You're setting an arbitrary deadline of 4 weeks to comply, yet you keep moving it out, so therefore the circumstances
is the
may not be so.
arbitrariness of the deadline something that we look at in light of what was happening in South Africa with the number of people being subject to Omicron, or is it something that we look at as SERB does, which is, oh, look, you moved it on. You kept pushing it back. It, in fact, didn't come to pass that the Omicron variant was as bad as you had anticipated.
I think the way to look at the deadlines is even the way to look at the circumstances as they exist now. When you're challenging, when you're trying to raise an affirmative defense that there's an emergency that's going on, that I have to implement my policy now and do post-implementation bargaining, again, it's showing that the circumstances are so dire that you have to deprive the unions of their statutory rights. I think what SERB is pointing out is that...
But see, I think you're skipping over the fact that this is a preliminary injunction.
Exactly.
So the snapshot is, oh my God, the sky is falling. You need to issue this injunction right then. Mm-hmm. And we're now a year and some odd months later.
Mm-hmm. Except that I think that the problem is that snapshot, even from start, has only been adopted by the city. Every forum that has heard this argument in terms of the context of this case coming into play, these circumstances were very different than the SERB decision. At the time when this mandate came into place, again, there had been a testing policy in place for 3 months. 87% of the workforce was vaccinated.
Right,
so
but
basically
then at the time, we have the lead health agency advising the city to say, get your whole workforce vaccinated, because it just isn't good enough to have the testing, because here it comes, Omicron is coming. And so in that context is that the single justice issues the injunction.
I guess I would take a step back, and the injunction was first heard by the Superior Court.
Right.
The injunction issued by the Appeals Court in February, at that point in time when she issued the injunction, I think one important point is that all she did was issue an injunction maintaining the status quo, which means between December and February, all unvaccinated employees in the city of Boston were working and testing. They kept moving the goalposts. All she did was enjoin the status quo. When December hit and the policy came into effect, nobody was taken out of work. All the unvaccinated employees that even were beyond the deadline were working with testing and masking. All she did was enforce the status quo. She has continued to enforce the status quo
that's just the definition of an injunction. That is neither here nor there. I mean, I guess I'm trying to figure out what you want us to do here.
What we want you to do here is to
why not vacate that injunction? It seems silly at this point.
Well, I think that
it's actually dealing with the merits.
The SERB is dealing with the merits, but the SERB, if you vacate the injunction, then we're back in the same place we were at before, which means that the city then goes and enforces the mandate. We're going to have 400 employees that are going to be fired. That is a possibility. As the city said, the policy's in place. It's been a year.
So is that a real possibility, or
100%. The policy, as you heard from my brother, is in place on paper. It has not been enforced for a year for 18,000 employees. But if you let this injunction go a month before we get to go before SERB and argue this impact issue, 450 people can be terminated.
Is that right?
Yes.
Or is it that because this is at the SERB, and the SERB has already weighed in and said, you need to further develop the exigency and bargaining requirements. If the city were to try to impose this before that's resolved, wouldn't you be back before a single justice seeking an injunction?
And I would just reframe what you said, because I think there's been a misframing of the SERB decision by the city. It's not that the SERB said you can impact bargain. The SERB said you have to impact bargain. So right now, they violated the law.
Right,
They
well,
did not
okay,
impact
but-
bargain
but-
unless they
but-
prove
but
there was an emergency.
They said again, I think they said it's a management prerogative, and there's impact bargaining, and the exigency issue requires further analysis. It doesn't rule for you or against you or for him or against him. It basically says this exigency issue is tricky here at that time. And by the way, just at that time.
Yeah, I agree with that.
But so can the city really, with that out there, they can't just if they immediately imposed a vaccination requirement now in that context, the law would be that they'd have to bargain it to impact, and they would need an exigency to do it. And then the question would be back to Justice Lowy's original question. In these new facts and circumstances, would that be required, right? Would they meet that definition? So they couldn't just go out and do this tomorrow. They'd have to meet all those steps or they'd be back enjoined, right?
I don't believe that is how the city views it based on the presentation of the city, that the policy's in effect. And the mayor has made it clear that the policy's in effect.
But that's just the fact. That's just the fact. The policy is in place and there's been an injunction on it. That doesn't mean anything about what's going to happen going forward based on what's happening right now, based on the circumstances on the ground right now. But I don't think we have to resolve any of that right now. Thank you so much.
Okay, thank you.